Portfolio Committee meeting on agricultural land reform and rural development. We have two items on our agenda this morning. One is with the Land Claims Commission, as we'll be looking into the progress that has been made thus far in terms of the settlement and finalization of old claims, that being the pre-1998, December 1998 claims. Further to that, honorable members, we will also be having a presentation on the status report with regards to the implementation of Kuyasa. Allow me, therefore, honorable members, to take this opportunity to invite Mamu Koboto, the Land Claims Commissioner. Mamu Koboto.
Good morning, Chairperson. I hope I am visible and audible.
You are visible and audible. You may proceed.
Thank you very much to Honorable Chairperson and to the honorable members of the Portfolio Committee. Today I am going to be presenting, as per request, I am going to be presenting with
recording in progress.
The Deputy Land Claims Commissioner. I am also supported by Mr. Lijuane Maputa, who is the Regional Land Claims Commissioner, and other members of the Commission. And Chair would like to take this opportunity just to thank you for allowing us this time to do the presentation. Can I ask Ralph if you can just put the presentation up? And Chair, I wanted also just to comment that I made some minor cosmetic changes to the presentation. I have given Ralph copies of the new presentation. No content changes, but just changes in terms of some of the aesthetics. Ralph, can you go to the next page, please? The focus of this presentation is going to give what we have settled to date in terms of the old order claims from 1995 to 31st of March 2023. And also we will give a report on submission of the report to the Land Claims Commission, to the Land Claims Court, which we refer to as the Lamusa report, which will also give the statistical information on claims that are settled and are still outstanding. Section 14 referrals, these are referrals in terms of Section 14 of the Restitution Act to the Land Claims Court. We'll speak a little bit about some of the key issues, including the challenges. The acting Deputy Land Claims Commissioner, Cindy Penyane, will give an update report on Project Kuyasa, and will also give a progress report on the research strategy, which is a key foundation to Project Kuyasa. Next slide. Next slide. Chair, this is the overall cumulative report on the claims that were lodged before the cutoff date of 30th December 1998. And as to date, we have already settled 82,976 claims across the province. Trying to move my screen so that it does not. Thank you. Overall, we have spent 53 billion rand in the project. 22 of that being monies paid for financial compensation, and 25 being land money that we spent on the acquisition of land. We also have 5 billion, which was allocated towards grants. We have settled over 3.8 million hectares and benefited over 2.3 million beneficiaries and 175,000 households, including 1,246 living with disabilities. Can we move to the next slide, please? This is the cumulative slide that speaks to the settlement and the finalization of claims over this same period. If you look at the first column on the far left, it gives you a total from year 1995 to 2013, a total of 59,712 claims that were settled across the provinces. And then you note that in 2014, it was 292 claims that were finalized then. And as if you notice, it progresses over time, and the highest claims that we were able to settle was in year 2018-19, where we were able to finalize 995 claims. I think that was when we were trying to really ramp up the settlement of claims. And then we obviously had some challenges, including COVID, where then you see the numbers dropping again. The last year, we finalized 429 claims, and therefore the total is 65,410. These are claims that have been finalized over the same period that I referred to. Next slide. I'm going to now give a report, Chair, on the Land Claims Court report that we give under the Lamusa judgment. As you are aware, on the 19th of March 2019, the Lamusa 2 judgment was handed down, and it, as one of the orders, we were given a requirement where we have to submit to the Land Claims Court on 6 monthly basis the following information. We had to give them the number of outstanding old order claims in each of the region, on the basis of which the Commission's administration is structured. The second was the anticipated date of completion in each region of the processing of all order claims, including short-term settlement targets. The nature of any constraints, whether budgetary or otherwise, faced by the Commission in meeting its anticipated completion date. The solutions that have been implemented or under consideration for addressing the constraints. And the last one was such further matters as the Land Claims Court may direct until all old order claims have been processed. So to date, the Commission has submitted 7 reports to the Land Claims Court in line with the judgment. And the latest report was submitted on the 24th of January 2023. Next slide. In terms of the report, this is the outline of what we submitted to the Land Claims Court. And Chair, if I can just add that whenever we submit the report to the Land Claims Court, we also submit a copy to the Portfolio Committee. So the timeline, we just focused on when restitution was, when it commenced the business process. We reported on Project Kuyasa. We focused on the policy, challenges that are there, and the remedial action, outstanding claims, and we also reported on legal matters. And specifically because the Land Claims Court, the acting judge president gave an order that all claims that are still outstanding, where they are not able to be settled administratively under Section 42D must be referred to court. And so those are some of the issues that we're dealing with. Next slide. And so again, we gave a cumulative number to the Land Claims Court of what we had submitted. Next slide. I'm not going to repeat that. And again, this is just a slide indicating how many claims were outstanding at the time when we gave the last report. So as of March 22, 2022, it was 6,685. These were pure outstanding claims, and year 2023, as it stands, we've got 6,571. And during the period when we were reporting, we had at that time settled 114 claims. Next slide. We made a provincial breakdown of the movement of the claim settled in terms up to Q3 then. And that was the outline. And again, if you notice, we still have the bigger provinces being KZN, Limpopo, Mpumalanga, Eastern Cape, and to a certain extent, Western Cape, having the highest number of outstanding claims. And so our focus is a lot on those provinces. You will notice again, Honorable Chair, that the Free State has the lowest number of claims that are outstanding and is almost done with the settlement of old order claims, including also the Northern Cape and Northwest. So we segregate the provinces according to the lowest number versus the ones with the highest number, and we group them into two so that we're able to deal with them, understanding the different dynamics that actually occur in each of those provinces. Next slide. I'm not going to repeat that. This is again the outstanding claims in the other provinces. And as I've already indicated, you can see in terms of the map where the bigger claims are still outstanding. And as Chair, you are aware, the targeted Project Kuyasa is intent exactly on dealing with the types of challenges that occur in the different provinces because they are not the same. For example, in the Western Cape, most of the claims that are outstanding are in the city of Cape Town, and mostly registered rights or tenants' rights that we have to deal with. Whereas if you, for example, go to KZN, you're going to find that these are big community claims that have got sometimes competing or overlapping rights, and also have issues around authority of traditional councils or traditional leaders. Next slide. This is the explanation. I've already indicated that the three provinces have the highest number. Eastern Cape, interestingly, has the highest number of financial compensation claims. And as a result, we see some issue around backlog in the payments of outstanding claims for beneficiaries for financial compensation. This is a historic issue that we are attending to. And the reason is that in the Eastern Cape, for example, I often make an example with a claim in Sipaqeni, or maybe it could be Thornhill, where you can have over 2,000 or even 5,000 beneficiaries that have to be paid financially into their bank accounts. And in order for that to happen, there have to be verification and bank accounts need to be active and all of those things. So our strategy in the Eastern Cape definitely is not going to be the same as that of the KZN province because of the nature of the payments, and the financial payment process is much more labor intensive, and in terms of the verification that needs to happen there. I've already spoke about the city of Cape Town, and in the Free State, I've already indicated in the previous slides that we've got 5 claims that are outstanding, and 3 of those claims are in court. So we'll have to wait for the court process to be finalized. Next. I spoke about the other provinces, but Gauteng, they've got outstanding rural labor tenancy claims, as well as large urban claims that are partially settled. For example, the Alexander claim, which was a claim of individual, multiple claims submitted, but we've got processes where some of the beneficiaries were paid and some were not. And there's some challenges around what is expected to happen around Alexander. And I'm sure you're aware of the Alexander renewal process that was spearheaded by the city then. And the interesting thing as well in the Northwest is that even if you see the number of the Northwest claims, that they've got a lower number of claims that are outstanding, but the extent of the hectares that are under claim in one claim, I think we've got one where it's over 2,000 hectares, 20,000, I think, hectares. And so that also becomes a challenge that it forces us to settle the claims in the Northwest in phases, and they are rural, and very often questions around necessary boundaries. And then, of course, this does not take into consideration the issue of post-settlement provision, which is an issue that we're continuing to battle with. Next slide. We also, in our process of dealing with Kuyasa, have been able to really separate the type of claims that we still have that are outstanding that we have to deal with. And if we look at the breakdown, we actually have 25% of the claims that are urban claims that we need to still settle, and 75% are rural claims, and that in itself tells a story, because urban rights are easier to identify. Very often there is a lot of history and documentation that are easily available for you to be able to make that determination, and also the claimants themselves have documents. Rural claims, on the other hand, as I've already indicated, can be quite complex and can be some discontent between claimants around the rights, including the actual extent of the rights that have been lost. Next slide. And so the outstanding portions per province is quite significant in terms of the complexity of the claims, which then causes a delay in the settlement of claims. And as I've already said, KZN has got the highest number of the claims outstanding, and Northwest has the highest number of parcels, land parcels that are outstanding. This is linked to 207 outstanding claims, but the portions are 3,204. So if you look at the table there on the right, Eastern Cape, in terms of those portions, it's 996 versus the Limpopo numbers, and the KZN portions. Okay, so Eastern Cape has got 996 claims outstanding, but if you look at the extent of the hectares, it's below 2,000. Gauteng follows, and then if you look at KZN, and you look at Limpopo, and again, if you go to Northwest, you look at the number versus what is outstanding. Next slide, please. And we have also broken it down in terms of the nature of the use of the properties in question. And you will see that we've got conservation, forestry, we've got mixed use, we've got ecotourism, sugarcane, which we identify separately. We've got claims that are undermining, farming general, agriculture, and residential. And as you can see that we've got those segregations, which are segregated by various percentages, and mixed use currently sitting at 49%. You can see ecotourism, which includes our work that we do with the Department of Environmental Affairs. We've got settlement models that we have proposed or refined to be able to assist us to deal with the outstanding land claims. And we are coordinating with the various sectors where we have met and proposed sort of a review in terms of how we settle claims as it stands. Next slide. I'm sure, Chair, you're aware of this slide in terms of the APP for 2022-23 and the MTF allocation. We set ourselves a target of 336 claims for settlement and 372 claims for finalisation for the year 2022-23. And of course, this is directly linked to the available budget and the staff that is allocated to the Commission. And we can confirm that we have achieved the targets and also spent the allocated budget. And I think that it's also an indication of the hard work that we are forced to undertake under extremely difficult conditions because of the capacity constraints that we have to deal with. Next slide. I've already dealt with that. Next slide. This is the previous slide just also gives you the outer years that we've been dealing with. And again, this is the report that we gave to the Land Claims Court. So some of the things that I'm referring to will be almost repeating some of the things that we gave. And as I already indicated, in year 2021-22, the Judge President acting of the Land Claims Court gave a directive for us in terms of how we're going to be dealing with the referrals of matters that need to be adjudicated by the Land Claims Court to finality. As you are aware, some of the matters cannot be agreed upon under Section 42D of the Restitution Act and therefore get referred to court for decision. And we've had some issues around the referrals of large matters where there are disputes with maybe the landowners who think that the matter was not necessarily ripe for court. We also have some issues around argument of defective notices in terms of Rule 32.5. And we had challenges around some of the issues on research and the technicalities that are associated. And the court also raised challenges around claimants who are not represented. And although in this instance, we've got the land rights facility that has been set up to be able to assist any claimant who seeks to approach the court. And also, I think that we did refer submissions to the Land Claims Court, but not to the extent that we thought we were going to be able to. The legal forum, which is the legal capacity in the commission, has come with a recovery plan, which will use to be able to catch up. We are also looking at an opportunity to brief junior counsel, although this is a challenge, next slide, because of some of the work coming from the State Attorney's Office. This is just a breakdown of the referrals that we've done so far to the Land Claims Court as per the order of the Judge President. Next slide. Overall, it's the target was 65, and we have not been able to do very well there. We also have challenges with the capacity of the legal officials that are allocated, especially on the issue of segregation of duties, as they have to deal with the litigation. They also have to deal with negotiations that happen with the communities and sometimes with any other legal issue, including having to visit the provinces, the officials, the communities with the project officers associated. Next slide. Next slide. Honorable Chair, just also to mention that the Land Rights Management Facility from January 2022 was taken over by the Legal Aid South Africa, LASA. This was a decision that was agreed upon by the Minister of Justice and our Minister as well. And therefore, this means that the allocation of attorneys for claimants who want to take the matters to court is now being dealt with by Legal Aid South Africa in line with their policy protocols of funding or supporting any individual South African who does not have the means to deal with their claims. I think that we have some teething problems with LASA, because there are some issues around their tariffs versus tariffs that were allocated during the time it was managed by the facility. And we've had some delays happening, and as a result, we've seen some legal representatives or attorneys and counsel withdrawing from some of the matters, or sometimes late payment, but that's an issue that we are attending. There's further an issue with the Office of the State Attorney. This was our report again to the Land Claims Court, where they have a new policy that requires that before an advocate can be briefed, there have to be 3 quotations. And we found that this prolongs the process, but we are engaging with the Office of the State Attorney to try and resolve this. For example, we had a matter in Northwest Province. I think it took over 6 to 8 months to allocate an advocate, and then that plays against our projected targets for each quarter, because then we're not able to deal with the matters. Next slide. I've already spoken also about the capacity constraints in the State Attorney's Office in general. And a lot of the time, our cases end up being dealt with by Mr. Sipho Mathibula in Pretoria, who almost has become, by default, the expert in the State Attorney's Office dealing with claims. But we're working on a solution there. Next slide. Again, just to remind us, Honorable Chair, that this is a report that we gave to the Land Claims Court, that with regard to the autonomy of the Commission, a business case was developed which provides for a detailed analysis and determination for the Commission to be a Schedule 3A entity. This was done and consulted upon, and the decision was made that the best entity to allow the Commission to be autonomous is a 3A entity. And remember, this also in compliance with the law, because as it was indicated, including by the AG, that in terms of the law, the Commission the Restitution Commission is a commission in law and should then by law operate as a commission unless we decide to amend the legislation for us then to operate within the department as a branch in the department. The approved business case was also submitted to National Treasury for further consultation. And because we also gave anticipated budget that would need both for warm bodies as well as for the actual settling of the claims. And we're still waiting for their guidance. A long-term structure linked to the proposed 3A entity has also been developed and can only be processed with the adoption of the proposed amendment bills and the business case that we have proposed. And this is going to be the presentation that Ms. Cindy Benyane, who is the current acting Deputy Land Claims Commissioner, will present on. It is also important to note that the Commission received an unqualified audit during the period under review. And also with no issues of emphasis. Next slide. We've also indicated that we've got an accelerated research strategy, which is the foundation of our backlog reduction strategy. As the Honourable Chair understands, in order for us to be able to settle claims, we need to have a full understanding of the nature of the claim, the extent of the rights lost, whether there are any competing claims and so forth. So research then becomes a key that we need to finalize. And we had anticipated that at least by this year we would have finished all of the outstanding, and we've got a variance of about 9% that we are dealing with. We also have, of course, the challenges where we wanted to make sure that we counter the quality of the research that has is submitted, and so we have standardized the formats that we use, and this is used across the provinces, and we've got a dedicated senior manager who coordinates the finalization of the research. And just also to mention that we have given research to external service providers through the normal procurement processes, and these were vetted, and to a certain extent we did not necessarily succeed with the quality of research that would come back despite our best effort. I think sometimes the understanding of the type of research that we require is not necessarily understood, despite the fact that it's when they are quoted, there are specific indicators on what we expect. We get sometimes research that is not conclusive, that is not able to allow us to take the process to the next stage. And so we are looking at a hybrid of continuing with external research support with those entities that we've identified that have been able to assist us with quality research. And also we are continuing to use internal research capacity, especially targeting those officials that we have seen are very good in researching so that we're able to finalize. We've also developed an SOP for the business case process, and this is we are implementing, which is also helping with the reduced timelines. Next slide. Additional challenges that were reported was a question of valuations in line with the property, the PVA of 2014. As you are aware, it continues to be a challenge, but we are working very closely with the Office of the Valuer General. The key issue now that comes continuously is that we've got offers that are rejected. These offers are rejected, which are made by the Office of the Valuer General. And we have sitting at approximately with about 85 million offers across the provinces that have been rejected by landowners, and 16 million offers rejected by the claimants, and we have had to refer some of those to the Land Claims Court for determination. And also the issue of how and who then must negotiate when there are rejections of offers is an issue that the Office of the Valuer General is still dealing with. And so we also have an issue that some of the offers, the landowners withdraw participating because of the delays that we sometimes get, because the Office of the VG also still continues to have some capacity challenges, despite some of their best efforts. I am aware, for example, that they've had some resignations, and so that also creates a challenge for us. Next slide. I've already discussed that. Next slide. Just a conclusion that the Commission may not, without the upliftment of the interdict, process new order claims in any manner whatsoever. This is in line with the Lamusa judgment. And in the meantime, the Commission has submitted a proposed strategy to the Minister for consideration on how we possibly could deal with the new order claims. That is, what we're saying is we need to be ready to deal with the new order claims if or as and when we are told that we have to start processing them, because as you understand, in terms of the order or the judgment, the claims that it's the 163,000 plus claims that were lodged in the new process are considered to be claims that are legally lodged and are valid, but have been ring-fenced. And we've been told we need to finalize the old order claims before we can deal with it. We also would need further engagement with Cabinet on the endorsement of the way forward, because remember that there is the amendment legislation was declared unconstitutional, and the Parliament was given 5 years to enact new legislation. Private Members' Bill was introduced, but the Fifth Parliament rose before that bill could be finalized, and it lapsed. And the Commission has, as part of Project Kuyasa, prepared the technical process on how we would proceed with the new order claims. Next slide. The implication is that the current allocated budget is not sufficient for us to be able to deal with all of the outstanding claims in an accelerated fashion. You'll see that Project Kuyasa sought to accelerate the settlement of the outstanding old order claims. We had a plan of 5 years, and we indicated that overall we would need an estimated budget of about 68 billion to accelerate. This was done, full deep analysis done in terms of those projections. And if you are aware, Chair, the current allocation and the rate in which we settle claims will take over 30 years if we go at the current pace, and at a cost of about 172 billion. So really our key focus is to try and make sure that we deal with finalization of all of the outstanding old order claims. But in order for us to be able to do so, we need to have the necessary budget that is allocated and the resources. Otherwise, we will, if with the current pace, it means that we will take over 30 years. Next slide. Chair, I'm not sure if you want, yeah, okay. I'm just thinking about the time, if I still have time, so that I can hand over to Ms. Penyane to present on Kuyasa.
Yes, we've got time. Please let them present.
Okay, so those are the challenges are in the presentation, so I won't go to them specifically. I'll ask Ms. Penyane to then go to the presentation. Ralph, if you can just go to the yes, thank you very much. Can I then hand over to Ms. Cindy Penyane to do a presentation, who is the current Deputy Land Claims Commissioner, and just to mention, Honorable Chair, that we have finally appointed a Deputy Land Claims Commissioner, and I'm sure that the Minister will make the announcement when we come back to do the presentation. Thank you.
Thank you, CLCC. Good morning, Honorable Chair and Honorable members. I hope all of you are doing well. Just to recap where Project Kuyasa comes from, around 2017-18, there was a host of studies and reviews that happened regarding the Commission. We had the 5 outcomes that came from Operation Pakisa. We had the Human Rights Commission doing a review on the work the Commission does. We have that DPME undertaking a study about the work of the Commission. We also had the finding the CLCC referred to from the Auditor General regarding autonomy. And a link to that also was the time where we started getting the 2 Lamosa judgments. Chair, the high-level outcomes that came from it were basically consistent across these studies and reviews. These high-level outcomes was regarding redesigning the business processes, accelerated settlement of claims, and then also sustainable settlements and the issue of autonomy. If you look at the Public Service Commission that they undertook around 2020-21, their findings, 9/11 findings, is similar to the work that we've started addressing under Project Kuyasa. So there's been significant progress from Kuyasa. I'll talk to that. We can skip this slide. I've basically dealt with that one. If we can then go to slide 41. Just to indicate, the slide 41 refers to, the slide is not moving on the screen, but slide 41 talks to the road to autonomy. When we got this finding from the AG, we undertook a review as to, and consultations with DPSA as to how the autonomous structure of the Commission is. The slide 41 demonstrates the processes we had to undertake to become an autonomous entity. We've developed the business case. You will see it's ring-fenced in orange, and we've also developed the draft legislation or the bill amendments that needs to be undertaken. Internal consultations is currently occurring, and I'll refer to that later on. If we then just go to slide 43, I'll then talk to the various work streams of Project Kuyasa. Chair, when it comes to Kuyasa, we've achieved about 95% of the targets that have been set in the work streams. The difficulty is just now the implementation for it to contribute to accelerated settlement. On this slide, the first work stream was issues regarding the backlog reduction, the audit of our statistics and what it represents, and then also our tracking tools, and also the monthly report, which you see demonstrated in the Lamosa report, as well as a backlog strategy to put forward to the court for the accelerated settlement of the claims that have basically been completed. It is all green. The next slide looks to our business process improvement. This is all green, it's been completed. We have standardized SOPs and policies, and all staff in the commission has been trained on this matter. On slide 45, you will see it is all green, the issue target regarding change management and communication. We've trained all change management officials in the commission according to the target that has been set. Slide number 46 is one of those where it's all green, but the impact of the implementation is not felt. This is regarding the redesign of the structure. I've indicated previously to you there's a two-step process because the AGR have started expecting us to undertake certain functions. That's why we had to have an interim structure as we move towards the long-term Schedule 3A entity. Now, from the Kuyasa side, it's been completed. It's now within the department. The department is currently consulting unions before the submission is submitted to the DPSA for formal sign-off for us to implement the interim structure. And then also just to indicate the proposed structure for the Schedule 3A linked to the business case has also been completed, but only after the legislative amendment that specific issue will be dealt with. Also to indicate on this slide 46, we've undertaken a skills review and also a transition plan as we move to autonomy has been completed. Then the next slide is issues of the organizational form. I've spoken to it, very much the separation between the commission and the branch restitution, how we will deal with the two-step process from the interim structure and then from the long-term Schedule 3A. The next slide is the settlement models on slide 48. We have got 7 settlement models that we had to review. We, as presented in previous slide, you saw sectors where most of our outstanding claims are in. The financial compensation settlement model is the settlement model where most of the settlements currently in the commission are happening, as most claimants prefer financial compensation. That has been completed. The visual documentation that we've prepared with GCIS has been completed. We are having handover the end of this month for us to have our final consultations with sectors that needs to happen. On slide 49, then refers to those 6 sectors where you have got the outstanding claims in. These settlement models are also completed. When we have the handover from GCIS, we will consult the final consultations. We've had numerous consultations with forestry sectors, mining, etc., etc. But this is the final with the training documentation that sector specifically asked us to prepare. So, Chairperson, I've basically presented the status of Project Kuyasa. We've hoped that with the formulation of this project, we are addressing the consistent issues that was raised regarding the Commission's performance in accelerating the settlement of claims. That is the progress. Thank you. Let me hand over to the CLCC for the last part on the research strategy. Thank you, Chair.
Thank you very much, Cindy. Chair, I'm not going to be long. This, as I've already indicated, that research becomes the foundation of what we need to do in order for us to be able to finalize the old order claims. What we have currently is a total of 789 claims that still need to be researched, that are regarded as pure research that still needs to be done, where there's a lot of work that needs to be done versus further research, which is 551. And then we then have the untraceables. We have a strategy around untraceables, and we continue to find the people that we are tracing through either tracing agents, collaboration, going to Home Affairs and other. So we continue to find people. So as soon as we find people, we then add them to the pure outstanding. And so that then that number of untraceables reduces while the number of pure outstanding potentially then increases. And then we also have deferrals, and deferrals that we have to do are in instances where we can't find anyone and the claim cannot be settled. So instead of us saying that we close the file, we want to approach court for us to, for the court to give us a final determination where we sort of house these claims and we hold them, just like with claims for minors that get taken by justice, and they put them away for future, so that in case any of the people who are entitled come up, then we can still then activate their rights, so that we don't really remove the rights that they have. So the work that we do is closely linked with Project Kuyasa. So the numbers there come from the configuration that we've done through Project Kuyasa. Next slide. As you can see again, that we still have the same pattern where it's the bigger provinces that still have those outstanding higher numbers, and we continue to support them in order for them to be able to deal with those. Next. This is just a breakdown per province in terms of what still needs to be dealt with under Kuyasa. Next slide. 159 in the Eastern Cape. We don't have any research outstanding in Free State. Gauteng, we've got 249. As you can see, we've got some which are deferrals. KZN, 773. Limpopo, 147. We've also identified that we've got some very good officials in Limpopo who are able to do research for us. Next slide. Mpumalanga, 309. Northwest, we still have 11 outstanding, and if you notice, they're all sitting at further research that needs to be done, and nothing that is new outstanding to be dealt with. You can see in the Northern Cape, we only have one outstanding research to be done. Western Cape, we've got 54. And if you notice, they've got 32 untraceables, which we are working on as well, which means that if we find all of those, then we'll have 54. Otherwise, if we're not able to find, then they translate to deferrals for court to guide. Thank you very much, Honorable Chair and Honorable Members, for the opportunity to present. And if you noted in our presentation, a lot of work has been done in terms of strategy for us to be able to have a more efficient and effective commission. Our policies are in place, standard operating procedures are in place. A proposed interim structure was submitted for approval, as well as a final structure under the 3A entity. We have consulted, and what we really are waiting for now is approvals for us to be able to then, and also get the budget to be able to then fast track within the proposed 5 years. Otherwise, if we do not get that, then we continue in the current pace, which is currently the situation we're sitting with. As you are aware, in our previous presentation to yourselves, we indicated that the Commission is currently operating at under 50% of the version 2.9 structure, which was the original structure of the commission then when it was set up, which was about 1,500, and we're currently operating at about 775. And if you compare the fact that when the commission started doing the work, a lot of the projects were sitting at the beginning, which was receiving the claims. And so that structure was suitable for a process then where everything is sitting on stage one. But with the fact that now in our business process, everything is sitting at various stages, including dealing with the issues of the beneficiaries themselves and the complexities of the claim, it is impossible to be able to do everything and finalize everything with half of that structure, which was for very minimal and streamlined work of receiving claims versus the work that we need to do now in the research, verification, settlement, post-settlement, dealing with CPAs and everything else, litigation that is associated. Thank you very much, Chair, for your time. I hand over back to you.
Thank you, Mama Koboto, Land Claims Commission, Commissioner and honorable members. We've received both the presentation on the remaining land claims pre-1998, as well as the presentation on Kuyasa. We'll now open for questions of clarity. Honorable Klabe. Honorable Klabe, are you there? We can't seem to hear you. You're not audible.
Chair, can you hear me now?
Yes, perfectly.
Chair, I'm taking this from the last presentation we had with Special Master. My confidence is very low, Chair. I'm looking at the capacity of legal services, the challenges within legal aid SA, and I want to know if the ministers both are aware of this low uptake of legal appointments, the attorneys, because for me, it's just another red tape that is delaying the whole process worse. State attorney, Chair, the 3 code is not working.
The House Chairperson.
I think Honorable Kape is duty whip in the House for the plenaries. She might be caught on to that. Honorable members will move on to the next Honorable Babama. I think we received an apology from Honorable Kruger.
Chair, just hang on a sec. Chair.
Yes.
Chair, there I am. Yes, sorry. Chair, my network and load shedding and what have you. Thank you, Chair, for the opportunity and thank you for the presentation. I think it's work in progress, and I just got a few questions, and seeing that I'm a new member, please accept my apologies if some of these questions are very old issues and maybe everybody on the committee know about them, but nevertheless, let me ask some of it. Chair, it's mentioned a few times that if we carry on the same road and path as we have done the past 10 years or so, it's going to take us 30 years to finalize the claims. And so, and it was mentioned that there's a budget shortage. But if you look at the 30 years, what it will cost over the 30 years, and if we fasten the process, it's more or less going to be the same. So, Chairperson, I was just wondering, what is the minister in the, and I know the minister is not on, I think she's not on. We need the money so that we can finalize this, Chair. So I just want to find out, what are the department doing to make sure that this money gets available so that we can finalize this claims in the next 5 years. Chairperson, and then I can't remember which slide it was, though. It was stated about the usage of the land, and one of the uses is mixed use. I would just like to know the composition of this mixed use. Is it, how is this compiled, the mixed use? It's a bit far, and I just want to find out more detail about the mixed use of the land. And of course, congratulations for the unqualified audit. It's not seen nowadays a lot in the government departments, but congratulations, and I think it's it's laudable that they have an unqualified audit. Chair, then the proposed strategy was sent to the minister. If we can just get more detail on it, maybe just when are we going to see the strategy, so that we can have some inputs in the strategy. And then the question about District 6, I just want to know how often are the department communicating to the beneficiaries of District 6. It seems like there's a breakdown in communications between the department and the beneficiaries of District 6. And I just want to know how often, if they at all communicate with the beneficiaries of District 6. And then the last question, Chairperson, and that is one thing that I'm very passionate about, and that is red tape reform. You know, wherever we talk about challenges in, not just in agriculture, all over government, we talk about red tape. Red tape is one of the stumble blocks, and the president appointed a person in his office, Mr. John Corsi, to reduce red tape and to reform red tape. But it seems like we still sit with this problem of red tape. And the red tape is created by bureaucrats. So from my side of view, I would just like to know, what are we as a department going to do about this red tape? Because it seems like if we can get rid of or reform red tape in the South African government, many of these processes and challenges will the processes will be much faster, and the challenges will sort of half over the next year or so. And it can't be difficult to reduce red tape or put a red tape reform strategy into place, because many countries did so in the past with many successes. But so I just want to find out if there's any suggestions from from the department of how we can reduce red tape, because it seems like the strategy at the moment.
That's where she has spoken about the provinces where there is a problem of many claimants, and that made an example of a Spadleni. And on that one, I would just want to understand now how far it has gone with that problem of having many claimants. And also, there is a situation of what do you call this? Poor representation of claimants. And that one also seems to have been a challenge. But now I would like also to know how far and that has been resolved, because it has been a challenge that was indicated there. And another one on the challenges, there is this one which is relating to the 3A institution, which is therefore making it a requirement that there should be first the amendment of that bill. But I would like to know that at the present moment, while the bill has not been there's not been amended yet, and then how the situation, how are they operating, how are the challenges being handled? And then the last one, I hope I'm not throwing anyone up under the bus here, on this part of the rejection by the claim by the landowners. Maybe this one only is limited to the committee, but I would like, if they have an idea that can this therefore provoke a situation where we need to revoke the Section 25, if it is so much delaying the process of delaying by the land claims, by the landowners. I thank you, Chair. Bye.
Thank you, Honorable Kapa. Honorable Tate Matiase.
Good morning, Talibog, Matiba.
Good morning, Tate.
Thank you so much, Honorable Chair. Look, Chair, look, I don't know who says the more things change, the more they stay the same. And the more we think that we're making breakthrough, the more we find ourselves stuck, if not in the present, but in the past. I'm saying this in the context of the decision that both the committee recommended to the department and finally implemented by the department to establish or to establish a memorandum of understanding and a service level agreement with Legal Aid South Africa to process disputes arising from land claims and unlawful evictions from farms and stuff like that. But it's like we have wrapped ourselves in bureaucratic delays, in bureaucratic excuses, all sorts of bureaucratic red tapes. The more things change, the more they seem to stay the same. What is this that we have been told today morning? Is there any intention on the part of people who are paid so handsomely to make not only the work of the committee in relation to oversight, but the lives of our people much better and easier? Is there any commitment on the part of officials? Is there any commitment on the part of the minister and her two deputies? Why are they failing to crack the whip? No, Honorable Chair, we can't sit back and say this is okay. I would submit here that the department is failing the people of the Republic. And therefore, These people who are in senior positions, I think some have overstayed their
We are losing you, Tate Matias. Are you still there?
their tenure. I'm still the Honorable Chair. I'm in Parliament here. I'm physically in Parliament. I would have been happy if this meeting, now that because I'm in Cape Town, this meeting was held physically. But I understand that you have been abroad and you might be on transit. Honorable Chair.
I am in Cape Town, Tate Matias.
I'm in Cape Town. Oh, thanks, Honorable Chair. Look, man, let's get some sense of what we are doing. The Legal Aid South Africa, if it's not providing the desired performance and outcome of what we thought they would be able to do, let's find alternative mechanisms. Let's find alternative mechanisms. Let's find an institution that is suitable to do the work to the best of its ability. We had assumed that because Legal Aid South Africa is state-funded, is the state institution, has necessary capacity to do this work, it will be able to help us, but it's like they're not helping us. Can the commission come maybe in a week's time with a breakdown of cases that have been referred to them? I know that I've sent several cases to the office of the minister, several of them. And I don't get a sense that there is any headway made in that direction. And the feedback I get to the complainants who referred these matters to me is a disappointing feedback. So I propose that, Honorable Chair, in a week's time, let's call the Legal Aid South Africa and the department to tell us how many cases have been referred to them, how many have been resolved, how many are yet to be resolved, and how many are part of a long list that they don't know when they will be resolved. Case by case, province by province, region by region, area by area, person by person. Secondly, can we get the commission to tell us the total number of the old order claims vis-a-vis the new order claims? Old order claims and the new order claims, and tell us, secondly, they must distinguish between claims that are related to land tenure, those claims that are dealt with by the special master. They must delineate the claims. They must say, these are the cases that are dealt by the special master, which are not related to land restitution, but they are land tenure claims. And these are the claims which are related to land restitution claims. They must also tell us how much has been spent so far on old order claims. The department at some point in the past said yes, they have spent about 45 billion. They need to tell us how much they have spent. And perhaps they must do a breakdown of that province by province, region by region. And now they are telling us their financial projections is that the government might have to spend 172 billion. 172 billion, in addition to the 45 billion that have already been spent for the next 30 to 40 years. 172 billion. Is it worth what we are doing? They must also tell us why do they think that 172 billion would be needed to spend on land reform, or specifically on land restitution. What is the baseline information for that? Is it because of the willing buyer, willing seller policy arrangement, which sitting where I am, the ruling party has discarded that policy and says we must find something more tangible and flexible. We can't just accept that in the next.
Recording in progress.
That's last point.
You do know that we have issues.
That's last
But before
point.
you point to neighbor,
We can't just accept that 172 billion must be used on land-related claims. It's just unreasonable, it's unfair, and we need to get to the bottom of what are the factors that makes the department to make these kind of projections, and how can we arrest this situation? Because this is bloodbath. This is fiscal bloodbath. This is throwing money down the drain. Honorable Chair, at some point we need to say this is unacceptable. And I trust in your leadership that this matter of 172 billion in the next 30 years shall have to be resolved once and for all. Thanks, Honorable Chair.
Honorable Ntate Matias, it will only be realized when political parties set their differences and we put expropriation of land without compensation to a reality. We move on, Honorable Treader.
Enkosi Sihlalo. Firstly, Sihlalo, let me apologize. I'm on my way to Parliament. I'm apologizing in case you hear a disturbance in noise because I'm driving towards where to work. I will be very quick due to that. Let me comment the LCRC for acquiring a very progressive audit outcome. Indeed, we commend their work. Chair, I am very much concerned, disappointed at the same time that there are not much strides when it comes to inland claims. I won't lament. The members have already added their feeling and their views on this matter. But Chair, to the commissioner, the commissioner mentioned that there are claims that offers that are rejected by the buyers, by the sellers or the farmers. Can we get a detailed information, Chair, as the committee, as to how many of those land or those farms and where are they? So that, Chair, we get a sense of what because as the ruling party, we made it clear that the willing seller, willing buyer approach, it was phase one. We are accelerating it. Indeed, Chair, you are correct when you say political parties must stop Shayama slogan and implement what we and walk the walk. Section 25 was put before us. The very same people that are lamenting now are the ones that rejected it. Sadly, it's affecting our people. Can we get, Chair, a detail of those land that the sellers or the farmers are not are rejecting the offers? Because, Chair, I'm asking this because Commissioner further said when it's taken to court, some of the farmers, they withdraw and come on board. So, Chair, I'm sensing an element of delay tactics deliberately so. That's one. The second thing, Chair, that I would like to request, seemingly we have our own challenges with inland claims and the office of EOVG, and also legal aid board. Chair, I would like to propose to the committee that we call these three, or we take a special look and monitor these three entities, because these three have a potential of delaying the national perspective. I thank you, Chair. I think due to my situation, I would further time write my questions so that I request a response, Chair. I cannot, the background is becoming noisy now. Thanks.
Thank you, Honorable Chwete. Honorable Mbabama.
Thank you, Chair. I've just come online, so unfortunately, I did not get the presentation beforehand. So you will excuse me on my comments. Thank you.
That's fine. Thank you, Honorable Mbabama. The Honorable Memasho.
Thank you, Honorable Chair. Let me take this opportunity and greet you, Chair, and all those are on the platform. I would also like to take this opportunity, Chair, to welcome the good work done by the Commission in getting a clean audit. Though we are all worried that one day I'm unhappy, a chairperson, in the way that things are not moving the way we thought things would move. But I heard when they were presenting that they were talking about their standard procedures that are in place, which maybe it would be some of those standard procedures which has policy and procedures that will assist them to implement some of this work that is not being implemented in time, because they now have these policies and procedures in place. My main question will then be focused on page 51, Chair, where they're talking about the types of researches that they did. But I saw on that slide, they had 0 in other provinces, which I think is Northwest and then Northern Cape, if I'm not wrong, if I saw it was. But I just wanted to know what happened. It can be that in South Africa, where people are looking for a land, the research can tell them that there is a 0 in that province. I don't think something was done well here. I think they need to tell us what is happening with this 2 provinces that have zeros, which I don't think is proper. We can't just say in this type of land where we are trying all of us to get a land, then at the end of the day, then we find that people are not being taken care of in other provinces. The other issue, Chairperson, which is my biggest worry, is that yes, the commission, we don't know how many land that
Memasho, are you still there? Honorable Masho, are you still there? Akbare Briet.
I'm sorry, Chair.
Are you back, Memasho?
Yes, Papa, I'm back. I'm sorry. We are having a bit of a problem with network here in Parliament. But what I'm saying is that, Chair, my biggest worry is that we have been requesting the Commission to give us how many land does the government have? How many farms do we have? We don't know what is happening. I'm going to go back to support the statement where one of the honorable members was saying that they must tell us how many cases they have in the old order claims. And also we must also look at the new order claims that they have. They must tell us, we must know. I think it's important for us to know those things. And then the other thing, Chairperson, which is the last one from my side. When you go around the province, you'll find that there is this LRAD farm that belongs to government, which were given to communities, where you find that it is not being finalized. People are putting those farms, those farms are not finalized. The commission is not helping us to make sure that those farms are given to the communities at the end of the day. We need to have this type of information to tell our people so that they must be able to know what is happening with those farms. Presently, we are finishing up our 10 Chairperson. We don't know how many land we have in our own land. We don't know. We have been requesting this. We don't have. And thank you, Chair. Can they help us? Can they let us know so that we can be able to talk to our people? They must know how many land do we have as government that is going to be given to our people. Thank you.
You're muted, Chair.
Mamo Breed, Agbare Breed.
Yeah, I think she said she will be in a committee meeting. In a plenary, sorry, for women.
Thank you.
Is back.
Honorable Dlamini.
Chairperson, thanks very much. Good morning. And the comments have been made by our colleagues. Firstly, I want to say I did listen to the presentation made by the commissioner and the deputy commissioner. The challenges have been made clear. I specifically do agree that there should be a discussion with the OVG and the land or the land legal person or people for us to understand how they have been doing their work and why we're facing those challenges there. I also note and appreciate the comment that relates to the matters relating to why a person in the name of Mr. Nkosi was appointed in the presidency for the long-ranging matters that relate to those issues that need to be taken on. Of course, it will be important that there be a clarity whether there has been success on that appointment, not only for the department, but it's a matter that relates to other departments too. I'm sure others can speak for themselves. But Chair, I would want to commend the commissioner on the report in general for us to understand where we are and then work with them to find solutions to these problems that are there, but also to say we are not happy in some of these areas, as she also has indicated areas of displeasure on the work that is being done. I would want to end here, Chairperson, and thank you for the opportunity you have given me. Thank you very much.
Sibalku, Abulela, Honorable Dlamini. The Honorable Ntate Muntwedi.
Ke a leboga modulasetilo, madume go wena le batsena kopano botlhe tsatsing la gompieno. Chair, quickly, one, I want to find out from the commission, when in totality will the old other claims be finalized? And have they quantified in terms of the cost required for them to be able to finalize all those old other claims? Chair. Now, the last presentation that we received, the commission indicated that Free State is done with the old order claims. And I asked a question in that meeting to say, now that they're done with the old order claims, are they then going to start processing the new order claims? I want to check how far is that, or Free State has to wait for all other provinces to finish their old order claims for it to actually also have to start with new claims, or they can start with new claims because they are done with the old order claims, Chair. Now, another thing, Chair, is that it's been more than 300 years since our people were dispossessed of their land. And I want to ask why is it likely that a new window will be opened for our people to lodge their claims? Because land that was dispossessed for over 300 years, only people given 20 years or so for them to put up their claims. There are a number of communities that only today are finding out their roots, where they then want to go and approach the commission to lodge land claims. So I want to check what is the status with regard to that. Now, the other thing, Chair, is that the commissioner mentioned of the rejected claims, rejected offers. I think Honorable Chwete touched on that. And I'm a bit concerned, Chair, that all of these are stolen land. How does somebody reject an offer is been compensated on a land that he has not paid anything and still refuse? I want to check what are the legal possibilities for the department to look into so that those people must be compelled to accept the offers, the reasonable, I must repeat, the reasonable offers that they have been given for stolen land. Now, I'm also interested, Chair, on I think Section 42C of the Act deals with funding for development. Now, I want to check with the commission to check them around the development funding that they issue in terms of restitution or discretionary powers to the minister to say how much is that, and does it get to beneficiaries? And for the 2022-2023 financial year, how much actually did reach out to beneficiaries, and in which provinces and the likes, Chair? Because I have a problem that if you take such funds and you use them under, you appropriate them under land and development support, it may be possible for beneficiaries of restitution not to receive development funding, because there's a lot of money that is hidden under land and development support, but the beneficiaries don't actually end up receiving that money. Now, when you look at the presentation also, Chair, there are number of officials in the Free State, I can well agree, because there are no active claims. They finish their old other claims. But in the Northern Cape and the Northwest, the numbers are very low. I know today in the Northwest, their numbers are very low. What are they doing? When they are getting paid every day, but the numbers in terms of the work that they're doing is that low, Chair. Is it possible that we may be having people sitting in offices and actually not doing anything, Chair? The last thing on my side, Chair, is that I have worries about untraceable claims. The department doesn't seem to be winning in terms of tracing them. I want to know why is it still stagnant in terms of you reaching out to all those beneficiaries that you are saying they remain untraceable. The last question on my side, Chair, is claims on state land. What is happening there? There are claims on state land, there are forestry, national parks, military bases where there are claims. And I get worried because you develop models for develop in terms of how to go about finalizing these claims, but nothing seems to happen, Chair. With that, Chair, thank you very much. I'm really sorry I have to get into a physical session.
Thank you, Tate Montwedi. Honorable members, is there any other honorable member on the platform I've not recognized who may wish to ask a question?
Honorable Tlhapwe is back, Chair. Thank you.
Yes, please proceed, Honorable Tlhapwe.
Chair, my apology for the earlier glitch. It's the problem when you are double parking, but I had to take some time to come and deal with these matters of importance. I was at a point, Chair, that I was saying the issue of land acquisition, taking it from the presentation we had last week from the Special Master. For me and for many people in South Africa remains a mirage. It's here, but you can't touch. And until something drastic is done, decisive, deliberate actions is done, Chair, when we receive reports like this. And this is what took me out of the house to come and speak now on these matters. In as much as the commissioner is trying her best, the issue of capacity of legal services, Chair, is a thorn in the flesh. She rightfully indicates that Legal Aid South Africa, that has taken over, takes so much time to appoint legal reps. And this is the decision between two ministers, Justice and Dalrat. Are they aware of this snail pace? Because for me now, bringing Legal Aid South Africa has choked the whole process even further. It's just another red tape. Now, we cannot fold arms as leaders of the two departments looking at now this problem. Even if you can say they have been brought, it has been brought up to them. If something doesn't work, why can't they just find a way of removing that? Because for me, state attorney, no capacity, according to this report. The attorneys, even in the state attorney, they sent files back to Pretoria, to whoever. 3 court system is not working. They took about 6 to 8 months to appoint an attorney in the Northwest. What happened to the issue database? That people could be on database are relevant people, because people that are specializing on land claims, the attorneys, could be harvested from the database. Now, if you want 3 courts and you take 8 months, that is why the outcry has been that claimants are even dying. There's a problem. That's why you can't even trace them any further. So this thing, Legal Aid South Africa, state attorneys and whatever, Chair, it needs really to be looked at. The Kuyasa project, Chair, becoming an autonomous entity, it's another pipe dream. Since 2019, when you look at those greens, everything else was done in 2019 and whatever. Then the other slides is 2020, 2022, back to 21, back to 2019. But the challenge, Chair, is that the project for me doesn't show any time frames. Well, when was this supposed to have been achieved? If the whole commission is still working on with under 50%, the stuff that they're going to, how are they going to really move into being an autonomy? And the elephant in the room becomes the need to amend legislation. The presenter is saying to us, even if tomorrow Treasury will approve, it means legislation has to be amended to accommodate this. So it will not happen in this end of time. According to me, it's not going to happen. Since we got here, it has been the same presentation. We are on the road to autonomy up to now. We were here last week talking about issues of limiting the bills that are coming before us, not only for us, because NCOP is choked also with these bills. So it means we can forget, or we must just make peace that it will not happen now. Hence, I'm saying we really need drastic and decisive steps on what we have to do, because everything else impacts on the release of land or acquisition, land with whatever programs that the commission is dealing with. With all these challenges, Chair, it comes to the research claims outstanding 789. Last week, comrades, honorable members were saying in Limpopo, we were told there were 2 claims that will be dealt with. What happened is only 1 claim that has been processed ever since we went to Limpopo. Now, with the 789 that has to be researched, follow-up research, you still have 551, and traceable are 299. Chair, we're having a challenge. I'm saying outside the commission, not blaming them or everything, we really need to zoom into the space and ask the minister to honestly look into how this can be helped. We're having all these entities. Next time it will be the same story. Let us, as this committee, when we get such presentation, just find time and zoom into the space and find a way that we say the department must bring tangible steps as to how they're going how they're going to deal with this. Otherwise, it says to me, like I started, land acquisition under all these programs becomes or remains a mirage. Thank you, Chair.
Thank you, Honorable Kape. Any other honorable member who may wish to pose a question? If not, honorable members, allow me to pose questions on my side, more so on restitution. Though not only a mechanism to address unequal land ownership patterns, it does, however, honorable members, affect many people, especially in rural communal areas, where communal land claims have been lodged. In terms of autonomy of the Land Claims Commission, Section 5 of the Restitution of Land Rights Act deals with the meetings of the Commission. In what ways are the meetings useful in the enhancement of performance of the Commission? Secondly, honorable members, legally speaking, how many members does the Commission have, and what is the quorum of the meetings? It is important for us to understand the implementation of some of these sections, especially now as the Commission moves towards autonomy of the Commission. In my understanding, honorable members, there are 3 statutory meetings of the Commission annually. I request that the Commission share with us the minutes of the 3 meetings held in 2022. It will help us understand the nature of the meetings. When it comes to the issue of finalization of land claims, which has been alluded that it would take about 30 years, in welcoming the performance that has been shown in the presentation, one must also note, honorable members, that the Commission is performing way less than what it was performing in 2019, as the Chief Land Claims Commissioner explained. We know that budget is insufficient and property valuation is one area of limitation. I want to therefore know what were the conditions enabling the Commission to finalize more claims in 2019 than in 2022. What can the Commission do to get back to the 2019 performance? In regards to the settlement of land claims, honorable members, The report states that numerous landowners raised objection on quality of research and other technicalities. We welcome accelerated research strategy, but there has been a number of initiatives in the past, including using academic and research institutions. Have all those initiatives not yielded desired outcomes? Honorable members, I note that the report no longer refers to those initiatives. It states that the Commission has developed standardized formats for all Rule 3 research reports. Research on untraceable land claims remains a worrying factor for me. We have had recommendations to the commissions about dealing with this matter. For example, honorable members, accessing Home Affairs database, SASA, working with institutions of traditional leadership, etc. Have these proposals been tried? If yes, what has been the outcome? That will be all on my side, honorable members. Allow me to hand back to the Land Claims Commissioner and the Deputy Chairperson, Uma Musindi, for responses. Thank you.
Thank you very much to the chairperson and the members of the committee. I will be assisted by the DLCC as well as the RLCC and other officials who are in the meeting to respond. If I may, I will start with Honorable Tlape on the first questions. The minister has been made aware of the legal aid challenges, we, as I said, continue to engage also with the legal aid to try and resolve some of those challenges. The question of land acquisition is, that is again, Mam Tlape, Honorable Member Tlape, apologies, is a focus of LDS, which is outside of the mandate of the Commission. In terms of the Restitution Act, we only focus on claims that were lodged before the cut-off date, and we settle those claims specifically in terms of what is considered as to be a claim that is valid in law in line with the Restitution Act. We will provide the data base that has been given to Legal Aid South Africa. I note your concerns around the issue of 2019 on Kuyasa, but I'll ask the DLCC to respond to that, including the issue of the timeframes for the legislative amendment. To Honorable Kruger, yes, we acknowledge the issue of the red tape, and which is why Project Kuyasa was developed to try and reduce some of the red tape. And that's why we've created new standard operating procedures as well as policy. And we've actually reviewed all our processes to try and reduce the number of days. We've done a full analysis on that. And on the issue to Honorable Member Kapa, on the issue of Sparkling, claims like that where there is financial compensation, the province specifically of the Eastern Cape continues to pay those claims. As I indicated, we have to do what we call a verification, and the verification comes from the originally dispossessed individual and the family, and we pay per household. But in certain instances, households don't want to be paid one amount as a collective. It has to be broken down into individuals, and so all of those individuals have to be paid. And in order for them to be paid, we need for them to provide proof. There's specific standard documents that they must provide to prove that they are the right beneficiaries. And until they provide that, then the money cannot be paid. So that also can become a delay. But otherwise, the province continues to make payments in all of the projects that are like that. We also have focused on a dedicated strategy to fast track any claims that have outstanding payments in the Eastern Cape. That's where we're developing that as well. And maybe also to mention that on the question of, okay, maybe I'll address that later. And the DLCC will deal with the issue of the 3A entity and the amendment of the bill. And on the rejection of offers, the offers get rejected under the Property Valuation Act, where it is the Valuer General who has the obligation in law to conduct the valuation, and the valuation is conducted based on those 5 principles under Section 25 of the Constitution. And it is only the Valuer General who is entitled under Section 12 of their Act to conduct valuations. So once we receive a valuation certificate, we have to then give it to the landowner or the claimant, who then must accept it. And if they don't accept it, then have to motivate with the Valuer General's office. For example, if they think that there are certain portions or something that was left out by the Valuer General's office, and then the VG must then give us a final certificate. And once that final certificate has been submitted, that's what we must place before the landowner. And then that is the question of just and equitable compensation, which must be determined. And if the landowner refuses that, because we all know that most of the basis for rejection would be that we're not giving them what they would get in the market, which then goes back to the question of the market value. We have no option then, unless if the minister would provide or make alternative compensation, which is separate from the value that has been offered by the VG. That would be a position that the minister would be able to take, but otherwise then the court would have to determine what is regarded as just and equitable, because in terms of what the VG has offered, because the commission can only then make that offer. We've got a list of projects that have been rejected, and we can make those available to the committee. On the issue of the SLA with Legal Aid South Africa, that is Honorable Matiase. We've already indicated that yes, there are challenges there, which we have highlighted to our principals, and we continue to engage. I must also mention that the Commission in the last 12 years has met its APP targets and expended all its budget for all of those years, which means that we have used all of the monies that are allocated to us each year. And so then the question that perhaps the committee should ask is whether if we allocated more money and more resources, we couldn't be possibly able to fast track the settlement of claims. I don't think that it would be fair for us to be expected to fast track the settlement of claims with the current budget, because we would not be able to do so. In fact, what we say is that we always have to monitor how many settlement agreements we sign off each financial year, so that we don't overcommit the commission or the department in one financial year to resources that we do not have. So our budget generally is around 3.2 billion each year. And I think the highest budget that we've had was close to 3.8 or 9 billion, but that includes compensation of employees, that includes goods and services, where we pay researchers and do all of that as work. And then the balance is what we refer to as household a budget, where we acquire the land and pay financial compensation. So if until this last financial year that we just finished, we spent all of the budget and we met our targets. I think that that is a reflection of the commitment of the staff that work in the commission, despite the very difficult circumstances under which they work on. And the fact that we have set up a strategy, which is the Kuyasa strategy, where we have actually tabulated exactly what we can do within the period of 5 years if we are given additional resources, including warm bodies. And the fact that we've refined our policies and our standard operating procedures, acknowledging the fact that as a commission, there's an expectation for us to fast track the settlement of claims. We can only fast track the settlement of claims if we are given the resources to fast track. If we are not given those resources, then we can only settle the claims in the current pace that we are. Not because we don't want to settle more claims, but it is the capacity that we have, and it is the resources that we have that dictate that this is how we should settle the claims. The total number of old order claims that were lodged was about 80 million, that's 79 million, 80,000, that was 79,000 plus claims. Old order refers to claims lodged before the cutoff date of 1998. And the new order claims that were lodged before the Constitutional Court declared the Amendment Act as unconstitutional was 163,000 claims. These claims, we don't know whether all of them are valid or not, because we were interdicted by the Land Claims Court from touching these until we've settled the old order claims. So that is the conundrum. We are expected to settle the old order claims in order for us to deal with the new order claims. But the budget and the expectation, therefore, in terms of the order of the LAMUSA, as I read it out, says we must prioritize the old order claims. So we are prioritizing the old order claims, but we're prioritizing them at the pace that is practical, based on the budget that is allocated and based on the human resource capacity that we have. So if we are given the budget and we have a strategy to fast track, we've said there is a possibility for us to be able to finish these claims, the old order, in 5 years, but we would need plus minus the 68 billion. And we've given a breakdown, we'll resubmit of exactly how we got to that and what capacity we would need across the provinces. And we've done extensive work in terms of locating actually where the claims are situated, the districts, the nature of the claim, the extent of the claims that are still outstanding in terms of portions, the hectares, the complexity of the claims. There's a question that relates to the issue of the special master that came to present. That is a process that is outside the mandate of the commission. Our role is to deal with claims under restitution, and we do have labor tenants that we deal with under restitution. The labor tenants that are dealt with by the special master are a completely separate process that does not affect the commission at all. Honorable Tshwete, not much progress has been done in terms of the settlement of claims. I would disagree, because if you look at the old order claims, we've settled over 90% of the claims, old order claims. We are left with the balance, and these are the ones that we're proposing that we should settle under the backlog reduction strategy, which is under Kuyasa. We will provide a detailed summary of the offers that have been rejected. And we appreciate the opportunity for us to be part of a meeting where the VG and the legal aid is present. Honorable Mahlo, the research that is there is just the last outstanding research that is there, and we are dealing with it both using internal and external service providers. External service providers and also the internal staff that we've identified that are good at doing research. and we've broken it down, and we've got a full strategy that we're working on. And we anticipate to be able to resolve all of that research within the year. We are not responsible for ILRAD farms. That is work of the department that is outside the work of the commission. Also, we cannot respond to the question of how much land do we have. That is the responsibility of the department. Again, in line with the Restitution Act, the only land that we deal with is land that is under claim under Section 2 of the Restitution Act. And so based on the claim form that is submitted, we then conduct research on whether the claim is valid, and then we restore per claim that has been submitted. So we don't look at generally how much land that does government have. However, we do have claims that are on state land, and we also settle those. The old, thank you, Honorable Dlamini, we note your comments, and yes, we have challenges with red tape, but as I've already indicated, we are dealing with those through the proposals that we've made under the business case, which we can again make available. Honorable Mutwedi, on the question of when we will finish all the claims, it depends on when we on the allocation of budget that we get given. If we get given a budget that will allow us to finish to implement our backlog, the strategy, the 5-year strategy, then we will finish them in 5 years. If we don't get given that budget, then we'll continue to settle the claims according to the budget that is allocated to us each year. And we've already indicated that potentially, if you look at the number of claims that we settle each year and the allocation of the budget, that it could take us 30 years. The Free State is done with most of the work. And what we've done is that we have partnered them with the Eastern Cape. They are assisting the Eastern Cape specifically on settling the claims that are adjacent to the Free State, which is the Jogabi district. And so they are 100% used to be able to do that. Further on, the Free State as an office has had challenges in that I think for the past 3 years, we haven't had offices in the Free State. The last offices were declared not habitable or suitable in terms of the act. That is the, forgot the name of the act that deals with the buildings. And we've been waiting and engaging Public Works and the other parties for us to finally get that done. Mr. Bukhatso also, who is the Chief Director responsible for Northwest Province, is also allocated to be a Chief Director to support the Free State so that he's able to do work both in the Free State and in Northwest, and now also supporting the Eastern Cape as the Chief Director in the Free State. I've already spoken about the rejected offers. The section 42C is a Restitution Act section that deals with discretionary grants that the minister can allocate towards development. The commission, while it has the limited budget that it has to acquire land or pay financial compensation, also has to allocate some monies towards development funds. We don't get separate funds for these discretionary grants. And we've got discretionary grants that were approved previously on claims that were settled that we continue to pay. So that also then has an impact on the amount or the number of claims which are recently approved claims that we have to we must buy. So we have to balance out the money that we have currently in settling claims, but also paying for those grants that have been approved or allocated to communities. I think you asked for a list. We'll try and provide that. The issue of the untraceable claimants, as we've indicated, is not stagnant. In fact, a lot of the times, the number of claims that have been or need research will then have to increase because we keep finding the claimants that were previously untraced. So we are using the suggestions that we've been given, but maybe we can do better, but we continue to find these beneficiaries and claimants. And once we do, we then put them under the research projects to be researched or projects that are outstanding, and then we move with the process. We also, as I indicated before, we use tracing agents as well. We communicate with the various departments. We've got people who actually make phone calls or even go to where these people used to live or where they are known to live to try and find them. And so there are success stories, and we're able to translate the untraceables into a claim that needs to be dealt with. We are dealing with state land, and we've got SLAs with the departments, other departments. I'm hoping that the DLCC will speak to the recent one, especially the forestry SLA that we've signed in order for us to coordinate. I'm trying to see what else. Honorable Chairperson, yes, we've got the issue of autonomy, as we've already indicated, and it's in line with the Restitution Act, and so we have to comply. From the side of the Commission, we are ready to meet the obligations of the issue of autonomy, but we require approvals and budgets in order for us to be able to. We have statutory meetings, and we will provide the minutes of the statutory meetings as required by the Restitution Act, and we continue to make sure that we meet those obligations. How many members of the Commission? I would have to check, Chair, but to clarify, because of the AG's findings, I think it was year 2019, where we were qualified because the Commission was not operating in the manner that it should as in a standalone commission. What we have done in the interim is that we have a commission, which is the commission in law as defined, and then we've got the branch restitution, which is the implementer of what is awarded by the commission. So I make an example of, I'll make an example of the, forgot the name of the project. If you remember that when there was the commission that was held by, Cindy, can you remind me the name of the? Desmond, the
Truth and Reconciliation Commission.
Thank you very much. The Truth and Reconciliation Commission, if you remember that the Commission's responsibility was to investigate, to listen, investigate, and provide recommendations to the Department of Justice, and they did that, and then they handed over their recommendations to the Department of Justice. So the separation of roles in this context is that the Commission for Restitution of Land Rights then is supposed to receive, investigate, and recommend the claims for settlement, and then the branch restitution is supposed to then implement the settlements on behalf of the minister, because at the end of the day, the person who is responsible for restitution is the minister, who then must implement the settlement. But the Commission's responsibility in terms of the law is to investigate and provide the minister with a list of recommendations on the claims that are valid for the minister to implement. So that's how we separate. And obviously the minister uses the DG of the department to do the work. And so in the context then of the Commission, as it stands, we are operating on two roles, which we shouldn't be. So I make an example and say that in the Northwest, we've got Mr. Lingani Bukhazo, who is the chief director responsible. So what he then has is two roles. He's got one foot where he is the implementer on behalf of the commission, where his role is to, after having received the claims, make sure that those are researched, and where we get to the point where the claim has been validated, Section 42D has been signed and approved, and at the same time, he is responsible for branch restitution to make sure that if the claim has been approved and the claimants have opted for restoration, that as his other leg as owner of branch restitution, he must make sure that he implements that recommendation and transfers the land. If it's financial compensation, he must ensure that each individual beneficiary receives that, deal with the setting up of CPAs and all of that, and coordinate with the department to ensure that the department deals with the question of post-settlement. So currently that's what we are doing, and as an interim. So we've separated the people who are supposed to be working for the commission versus those who are supposed to be working for the department under restitution. But the separation to a certain extent is artificial because the commission is doing all of the things that should be done separately. We'll provide the minutes of the meetings for the statutory. The budget, the reason we're able to expand highest in 2019-20 is that we had a higher budget, and we also had many more people. And I think that with the merging of the two departments and the interim structure, it is, and the resignations of people because of the environment, which is high pressured, we continue to lose people. And at some point in time, over time, government had moratorium on filling of vacant posts, which affected us. And when it was time, then the structure interim was confirmed to be half of what was made available at the beginning of the commission. And so we're working with less and less staff members as we go. And so that obviously has an impact on the work. And I think 2020, we had challenges with COVID where we had projected much more, but we had to review our APP because we couldn't do our work because we were working from home, and sometimes there was a complete shutdown. We are continuing to deal with research using both internal and external. And so the process of dealing with untraceables and all of that is still something that we'll continue to deal with. And in my perspective of view, I don't think that it is not moving. And it's yes, it is a challenge to a certain extent, but it's a challenge that we are continuing to address. We've got a communication strategy that's just been recently approved as well, where we are continuing to do our district-based consultations with claimants. We target areas where we know that we've got claims that are outstanding. We're inviting claimants who have not had their claims settled to come to the offices as well, while we also go out there. But what we are finding is that a lot of the claimants that call or write to us are not the claimants that we're dealing with, which are the old order claimants, because we are in touch with the old order claimants. It's mostly the new order claimants who want to know when we are going to start settling their claims. And so that is a challenge that we continue to face, because until we're done with the old order claims, we cannot settle the new order claims, or until the interdict has been lifted. So even within the Free State, because there is one commission and there is one interdict, unless we go back to court to get clarity, we cannot then deal with claims in the new order claims in the Free State. However, there is a case currently which is called the Vulamasango case, which is a case that has been lodged by an entity, NGO, called Vulamasango, where they are saying that the commission or government must open and start settling the new order claims, especially the ones that are betterment claims, because we had stopped them in the old order phase from lodging claims. So that is a matter that potentially can force that the commission starts dealing with new order claims even before the old order claims are done, but the case is still pending in court. Cindy, can you please then clarify specifically on the issues around Kuyasa? Thank you. Thank you, Chair.
Thank you, CLCC, Honorable Chairperson and Honorable members. Let me start off by addressing the question that has been asked regarding our standard operating procedures. I've presented before that under Kuyasa, we are looking at streamlining business processes, and also many of the red tape that is there, we've acknowledged for it to fall away. I've previously presented at our best, the commission and on average takes about 543 weeks to settle a claims, up to 20 years, which is a very, very long time, which is also unacceptable. The streamlined business processes is looking very much at reducing the time frames we use in settling a claim. One of the reasons that we've got such long periods to settle a claim, for example, is the centralization and the existence of only one regional land claims commissioner. That's why you find much duplication in the system, the checker checking the checker, many things being done on a provincial and national level. And when many of these issues fall away, the time period that is spent on addressing a claim will be much reduced. Not to become very academic, when we modeled Kuyasa, we focus on the academia and Mackenzie 7 S's. Just to remind members again, it looks at structure, systems, strategy, skills, staff style, and the systems, and for these to be synchronized. So that is what we base the work on in the reduction of the red tape. Then the CLCC addressed the issue of the when we started Kuyasa, we indicated we had to develop a database, and also that the database was audited by an independent auditor. You will see since the beginning of Kuyasa, the old order claims reduced from about 7,500. It's now in the region of about 6,500. Every single day we settle new claims. That is what happened. The CLCC referred to the new order claims, which we are prevented to touch, which is 160,000 claims. Just to indicate, the database that have been audited does not only represent statistics, it represents the various sectors the claims are in. That's why we've identified 6 key sectors. It identified the portions of land. It has identified the cost that is going with these portions of land. It is identifying in our business processes where are the blockages when it comes to the specific matter. Just to indicate, the 69 billion comes from that specific audited statistics, and we have done some modeling. Obviously, you saw today we are reporting on a research. If the research is finalized, that must be added to the database. And also if you CPI, and if we take so long, the 69 billion can increase to 176. We put forward a backlog strategy that if we have sufficient financing, and when we've got sufficient money that we are proposing, there is work that has been put forward for this specific work to be finalized in a 5-year period. So I've spoken about the standard operating procedures. I've spoken about the statistics and the financing that goes with it. Let me then also just address the question that the honorable member asked regarding when Kuyasa was supposed to be completed. The honorable member is correct. When we presented Kuyasa, we've indicated that Kuyasa should be completed 2021, 2022. Then COVID hit us. We were delayed due to us not being able to access physical files, not having one-on-one meetings on project site visits. So Kuyasa pushed, or the COVID created a pushback of the deliverables of Kuyasa targets around 2022-2023. So the delay that was happening in Kuyasa targets was only basically due to COVID. Then the question was asked regarding the commission meeting, and CLCC to some extent explained the commission versus the branch restitution. I just want to give statistics of meetings that happens that contribute to board's performance management. We are supposed to have 3 out of 3 commissioners meeting. We have complied for the past few years. We have commissioners meeting. We have got monthly branch management meetings. Unfortunately, due to the lack of this interim structure being implemented with us having a branch head, for now, the branch management meetings are chaired by the Deputy Land Claims Commissioner. We've got the regional coordination meetings on a monthly basis, which creates consistency on how matters are implemented across provinces. We've got operational implementation meeting. And then when it comes to budgeting our finances, we've got finance meetings which we call FinCom. So minutes of the commission meetings and the branch various meetings and forums that we've put in place based on the strategy that is also available to be provided. Then the question that the honorable members asked was regarding state land and also regarding the settlement models. Honorable members, if you are aware, I've indicated 6 priority sectors where claims are in. Sectors themselves has gone so far because the issue of land claims is such a risk for investment in sectors. They've included us in their sector master plans and strategies. I'll make example. I won't go in every single strategy. For instance, let's look at forestry. We've been included and we contribute to the forestry master plan reporting. So at their portfolio committee meeting on a quarterly basis, they report on the master plan. We are part of the MOU the department signed. We have a specific task team that has been established on a quarterly basis. We look at the unblocking of challenges in both private and state land. So we meet on a quarterly basis. So those are some of the steps that we've put in place for the acceleration of claims within the 6 key strategies. And the settlement models are basically only focusing on the sustainability of the sort of packages that gets handed over to claimants and for sectors to be coordinated. Then, honorable members, just to add, the matter that is being observed in the Free State currently will also be observed in 4 other provinces. I call it 5 small provinces. By no means are they small, it's just small due to the number of claims. These provinces are Gauteng, Free State, Western Cape, Northwest, and Northern Cape. Now they have got the least number of claims. There's a strategy that the Commission have adopted where that will be implemented from this financial year, where we are looking at the accelerated implementation in these smaller provinces. Some of these provinces are estimating in the next 5 to 7 years they can be finished with the settlement of all old order claims. So we've learned from the situation in the Free State how we need to deal with it for the reallocation of staff to other provinces. So we don't lose that specific skill base. There's many lessons we've learned in the Free State. The acting head of the Free State is in the meeting. He can also add to that as to what are some of these lessons and key findings we are taking to some of these smaller provinces. I think I have addressed all the questions. The question on autonomy, the last one, just to indicate, we have handed over the interim structure to the department in 2021-2022, and the draft bill has been ready during the previous financial year 22-23 with the business case for further processing. That's where I'll park the issue of the autonomy. Then when it comes to just the issue of financing, we have started the process of engagement with National Treasury for financing over the next MTEF. On average, we get about 3.5 billion, but we've also prepared a draft cabinet memorandum that will probably finalize after the budgeting process with Treasury for increased financing to the Commission to finalize these old order claims. The first meeting regarding MTF planning only commenced yesterday, setting out the guidelines and so forth. I think I've addressed all the comments and questions that have been raised. Thank you very much, Chairperson and members.
Chairperson, if you'll allow me, please, there's two questions that I didn't respond to. It's the one on District 6. Just to mention that in terms of the court process, the Commission is required to submit quarterly reports via court on District 6, which we do. And we then also share that with the community itself. There are various role players in District 6 and as well as the civic. We make those submissions as well, that communication. Further, we communicate directly with each household that is affected, either the ones that are already on site in phase 1 and phase 2, and we regularly communicate with them. Claimants who are ready for the other phases. And also DM Squatcher continues to interface with the beneficiaries there. And I know that he was communicating with us also for a potential meeting with some of the claimants. Insofar as it relates to the number of claims that have been settled to date, I think I did indicate in I think one of the first slides where I indicated that we've acquired over 3.8 million hectares of land, and the cost of for land acquisition was 25 billion. For financial compensation was 21 million. We benefited over 2.2 million individuals and about 452,000 plus households, and 175, I think, female-headed. And remember, the numbers change as we continue to settle claims. And at a total cost, I think we said it was 54 billion overall, with the 5 billion being grants that have been allocated to these claimant communities. Thank you very much, Chair. Can I please hand over to you?
Thank you, Mamu Koboto, Land Claims Commissioner, and the Deputy Chairperson, Umamu Sindi. Honorable members, any follow-up questions on the presentations put before the committee by the Land Claims Commission on the old order claims, which are pre-1998 December, or on the Kuyasa presentation? Honorable Mbabama.
Thank you very much, Chair, for giving me the opportunity. Chair, we've been listening to the Land Claims Commissioner for quite a long time now. In fact, it's been 4 years now with this 6th Parliament. And she has been saying the same things, telling us the same things that are impeding progress in the Commission. And I'm just wondering, what else can we do? Or maybe we need to talk to this Etaleni, on the side as a committee, to say what else can we do, because this problem is a budget problem. It is a capacity problem. It is not as if they are not doing any work. In fact, when I spoke to the minister, she said herself that they were doing quite great work with the restraints that they have. So really, where does our oversight role start and where does it end? if there is a problem like this that is outside of the entity itself, what recourse do we have as a committee? And I'm asking these questions to all of us because I also don't know the answers, honestly. Is it a matter of getting the treasury here with the minister to talk and say, are we accepting this as South Africans? Are we accepting that we will never finish these land claims? Or is there a plan in place from treasury maybe in the future? Exactly what is going to happen? What is our recourse as a committee in something like this? Thank you, Chair.
Thank you, Honorable Mbabama. You may lower your head. Any other honorable member who has a follow-up question? Thank you. If not, let me hand back to the Commissioner for a response on that, and we may then close the deliberations of today.
Thank you very much, Honorable Chair. I think that if I'm not mistaken, I see the DM's presence, or I think he put his hand up. I was going to say that some of the things are things that can be responded to by our political principals, and perhaps I'd like to, through you, Chair, request that I give the DM the opportunity, because the issue that has been raised by Honorable Babama is, I think, a political one. Thank you.
Thank you, thank you, the Land Claims Commissioner. Any further input on the matter relating the presentation of the Land Claims Commissioner or on the Kuyasa issues? If not, honorable members, allow me to hand back to the officials of the department, the DG Tate Ramasodi, and the executive of the department, as the Honorable Deputy Minister Ubao Skwacha is with us, for their comments on the presentation or for answering of the political questions. Thank you.
Thank you very much, Honorable Chairperson. May I respectfully start by forwarding a profound apology for arriving a few minutes late in the meeting. It was not because of any disrespect to you and the committee members. It was because of teething problems in my own office that had to be addressed. Thanks for the opportunity. Chair, there was an issue just as I respond to this one. Before Honorable Kape was cut off, she had been raising the issue of low confidence, and she was strictly, as she came back, calling for decisive, deliberate action. I take it that it is a matter that the political authority cannot ignore. As she says, if the matter of the minister and the Minister of Justice was to meet so as to enhance our work, if it does not deliver the necessary results, it is something that has to be looked into decisively. I want to say one does note that. Chair, quickly, without wasting your time, as it relates to District 6 raised by Honorable Kruger, as our CLCC has indicated, we're looking at a potential meeting there of everybody to deal with this particular, to make sure that the information does flow. I think honorable members know that the former Deputy President was there sometime last year. Chair, I may want to say that Honorable Mahlo raised the issue of land and how much we have in South Africa. Former Minister Nkwinti had auctioned a land audit. I suspect that because it was comprehended into a booklet, suspect that it is still available and probably would want to revise it and bring it to the attention of the portfolio committee. The second last issue, Chair, that I want to raise, probably it's connected to the one also raised by Honorable Mpapama. It was raised by Honorable Muntweji. He spoke about a new window, likely or not, and he advanced the reasons. We would recall that when our first state president, Matiba, this happened during his term and it was reopened. There's been quite various reopenings. One of the thinking behind the former Minister Nkwinti, and he's one of the reasons why he was strongly in support of the commission, because the commission's autonomy would also give an opportunity for South Africans, because the commission will be operating and it will be a continuous process. Now, what I want to say around this issue by Honorable Muntweji is, and Honorable Mpapama, my understanding, which I think is the right understanding, is that all these issues are tactics to arrive at a particular situation. And that situation is an equitable, non-racial, non-sexist South Africa. Now, the form is to how we arrive there. The issue of, as the CLCC was painfully explaining, and that about, it is a matter that Honorable Mpapama raises, and the committee maybe can engage aside. But government itself, we are looking at, as a department, of making an assessment about how we go forward, present that to our cabinet to look into whether at this juncture, what is the way forward in relation to both human and financial resources, if we are going to be able to achieve what we want to achieve with the resources necessary. So my own submission is, I think Honorable Mpapama and your good selves are raising a genuine question. It is a question that the political authority of the department is also beginning to be seized with. How do we achieve an equitable South Africa, a redistributed South Africa, in the light of the challenges that we do face now? Lastly, Chairperson, oh, no, that was about the last. So I'm saying that it is a challenge that we need to look into forcefully and deal with. Thank you very much for giving me the opportunity, Chair, and everything raised here is well understood. Even the frustrations raised by Honorable Matthias, it is not out of lack of not being serious about what we are trying to do, as I've indicated. Thank you.
Nkosi kakhulu, Deputy Minister, for your input. But I do believe that the officials of the department, perhaps the executive, be more precisely, would need, in a way of taking this matter forward, to look at a date where they can gain legal aid on this issue and engage with the Minister of Justice, Minister of Agriculture, Land Reform and Rural Development, and the Deputy Minister, including the Special Master and the Chief Land Claims Commissioner, to discuss this. I would think, honorable members, it also is a matter that requires the National Treasury to look at funding of restitution. But with the necessary funds required to oversee all these claims settled, I truly believe that the only manner and way you'd be able to fast track this is for us to implement expropriation of land without compensation. And in doing so, we'll be able to realize this gross and grave injustice that has led to land hunger corrected. Honorable members, that was the only item we had for the day. I therefore want to thank you all for having availed yourself for this Portfolio Committee on Agriculture, Land Reform and Rural Development. I want to thank the Land Claims Commissioner and the Deputy Chairperson of the Commission, Mamusindi, and all that took interest to avail themselves for this meeting this morning. Now we have ongoing mini plenaries that I've seen Memo Shaw as well as Honorable Kape in the House in the Good Hope Chambers. Honorable members, the mini plenaries will be continuing this afternoon. For those that are in the precinct of Parliament, we'll see you in the House. And for those that are joining us on virtually, please do join in earlier so that we may have a smooth engagement in the afternoon. I wish you a great week ahead, and please take care of yourselves. Honorable members, the meeting stands adjourned.
Thank you, Chair.
Thank you.
Thank you, Chair.
Thank you. Bye-bye.